Welcome to the PCI Practical Matters podcast, Top 10 Tips and Traps for Bid Protest Part 2. Once again, we're joined by Cy Alba. Take it away, Cy.
Thank you. Yeah, I'm Cy Alba. I'm a partner in law firm at Polaro Mazza, and we're here again talking about bid protest issues. Last time we kind of went through the setup, I think, about where to file, why you would go different places, how the rules work, and the benefits, kind of pros and cons of each of those choices. Now we're going to kind of talk about some of the more nuts and bolts, some of the nuances in filing these protests. And first, we're going to talk about getting a stay. So we alluded to that in the last session, but when you file a protest, if it's a GAO under the Competition and Contracting Act, you get an automatic stay. So if you file something before the bids are due, you file a pre-bid protest or pre-award protest, then in that context, if you file it in a timely manner and in an appropriate period, which is before the date and time for the submission of proposals, or if there's not enough time to file it, so for instance, the agency issues some modification and there's only 2 hours left before the deadline, then you have 10 days from the date that you knew or should have known. But generally speaking, you have to file a pre-bid or pre-award protest before the date and time for the submission of bids. If it's a post-award protest, you have to file within 10 days of the award date or 5 days after debriefing, whichever is longer. These are deadlines to get the stay, the automatic stay. If it's a pre-bid protest, you're going to get a stay on the award, not the evaluation process. They can continue with the evaluation, they just can't make award. And you're going to get, if it's a post-award protest and you file within 5 days of the debriefing, that's a required debriefing, get into that in a minute, or within 10 days after award, then you get the automatic stay on the performance of the contract because it was already awarded. So in either of those cases, there is an automatic stay put in place. If you're at the Court of Federal Claims, while you don't have those sort of strict timelines of when you have to file something, if you wait too long, the Court of Federal Claims is unlikely to grant you an injunction because you don't get the automatic stay at the Court of Federal Claims like you do at GAO or also with the agency. You're supposed to get automatic stay. If you go to the court, you might have to argue for it, you might have to file for an injunction, but you don't have those strict timelines. But it's still the sooner the better, because if you're arguing for something like a temporary restraining order, preliminary injunctive relief on performance of a contract or award of a contract, one of the things the court looks at is the balance of the harms. And if you waited 3 weeks or 4 weeks to file something and the contract's been going on for a month already, and you say, oh no, we need to stop that contract, it's too important, if the contract continues and it's going to harm me. Well, sure, it probably will harm you if that contract continues, but what's the harm to the government? What's the harm to the public? What's the harm to the company performing that work? How is that work going to be done? These are all factors that come into play. Whereas if you go to the Court of Federal Claims sooner, let's say you wait a week or two, which is more reasonable, and then you file, you're more likely to get a stay on the performance or get an injunction against the performance of that work or the award, because you haven't waited so much time. Also, if you're sitting there arguing for some sort of injunctive relief, that doesn't necessarily stop the government from issuing a bridge contract or something like that. If they issue a bridge contract and you think that bridge contract was inappropriate, that's actually another separate protest. It's not raised on the same protest that you already filed. It's a second protest. And if you protest that, all these same rules apply. You can get a stay on that of performance and everything else. The agencies also have the ability to override a stay. So if there's something that is very critical to the agency, that they cannot wait 100 days at GAO, or they cannot wait for the full Court of Federal Claims process to go forward, they can override the stay. And when they override the stay at GAO, for instance, then they make some determination, like a justification authorization that you might be used to. They make some determination that due to the criticality of the requirement or due to other harm, some reason, they're not going to stay this procurement, and instead they're going to move forward. When you file a GAO or the agency and they override that stay like that, you can challenge the stay override as well, but that too is a separate protest. So when they override the stay at GAO, you can go to the Court of Federal Claims and you can file a protest challenging just the stay override. So your protest on the merits of the case is still going through the same process at GAO, that 100-day process, while the stay override alone is being challenged at the Court of Federal Claims. You can go through that process. The court will then evaluate. Sometimes it requires entire briefing. Sometimes the agency just says, forget it, it's not worth it, we'll put the stay in place. But if you had to challenge it, it would be the same process you would have in a standard protest. You would file it, you would have a hearing, the judge might want briefing, you might have different motions going back and forth with responses and replies, and that whole process can happen. Usually it's on an expedited timetable. And depending on what the judge says, if they enjoin the override, then the stay is back in place at that point, and you continue through GAO. So that is a process that can happen, and it's not that uncommon that when you have to go to a stay overrides scenario that you end up at the Court of Federal Claims. If you don't want to file that separate action at the Court of Federal Claims once you got the stay override, then you can choose to continue through GAO. There just isn't a stay on the contract any longer that you're protesting. You could also choose sometimes to say, well, if I'm not getting the stay, that was the whole reason I went to GAO, I might instead go to the Court of Federal Claims because, like we talked about in the first session here, that you might get more documents if you go to the court. So maybe you pull the entire protest at that point, you file at the Court of Federal Claims. That also lets you attempt to get an injunction, so something like a second bite at the apple, to try to get a stay at the court instead of relying on the automatic stay at GAO that the agency just tried to override. So that's sort of how the stay works. And again, at GAO, there's very, very strict timelines of 10 days after award for post-award protest has to be 10 days after award or 5 days after a required and requested debriefing, whichever is later. Now, that's going to be important in a second when we get into some of the debriefing rules. If it's a pre-award protest, whether it's at the Court of Federal Claims or at GAO, you generally have to file that before the date and time for submission of bids. So the bids or the proposals are due on Friday at 2 p.m. Central Time. That's when the protest is due. Okay. If you file it after that point in time, if it's a GAO, you will be untimely in most circumstances. There are scenarios you can deal with that for most circumstances, you'll be untimely. At the court, you can also be found untimely under a case called Blue and Gold Fleet, which, funny enough, was the first Court of Federal Claims protest I ever worked on as a junior associate many moons ago now. And in that case, the court took the rule from GAO and applied it at the Court of Federal Claims. That's been pushed back a little bit, but it still generally applies, so remember that fact. Now, going on to, well, you said 10 days after award or 5 days after a requested and when requested required debriefing. What does that mean? What does it mean to have a required debriefing? When is it not required? How am I supposed to know that? Well, that is a very important question, and this is a good thing to understand, because when you have a debriefing requirement in the FAR, right, you have it for some procurements and not others. So if you're under a standard FAR Part 15 negotiated procurement, which is what most procurements are out there, they go through FAR Part 15, that debriefing is required when requested, okay? FAR Part 16 generally uses FAR Part 15 procedures, so for IDIQ contracts and things of that nature, the same thing applies. It is, though, when requested and required. So the FAR, the DFARS, generally requires that you request a debriefing within 3 days of when you knew or should have known of the issue. So when you get that notification that you lost the contract, you've been removed from the competitive range, whatever it happens to be, you have 3 days to request it. I would recommend, if you're looking to protest, or even if you just want information as to why you lost to help you next time, which is what debriefings are really for, ask for that debriefing right away. There's no magic to it. You just have to say, I'm requesting a debriefing, and that's it. Okay? When you do that, if it is a situation that's FAR Part 15, FAR Part 16, some of the other ones, if it's a required debriefing then, because you requested it within the 3 days, then it is required under FAR Part 15. They have to give it to you. You cannot file a protest after you've requested a required debriefing and before you've gotten it. So if the agency is going to wait a while, then that period of time, if you file a protest because you're sick of waiting, a week or something like that, and they haven't given it to you yet, if you file a protest, you're going to be dismissed as being premature. So once you've requested it, you have to wait until you get it. If it is a required debriefing, again, generally FAR Part 15, FAR Part 16, if you request it in 3 days, it is required. Other very common misconceptions is like GSA schedule. Okay, FAR 8.4. There is no debriefing requirement in FAR 8.4 for any task order or award, BPA, whatever it happens to be, under a GSA schedule. There is no required debriefing. So if you request a debriefing and the government says, okay, yeah, sure, we'll get back to you, we'll get you your debriefing, and then you did it the same day. So you found out you lost, you requested the debriefing, it was a task order or GSA schedule. They wait 11 days, okay? And in 11 days, they give you a brief explanation of award. And you're like, what is this? This doesn't even tell me anything. It's just 2 sentences about how they followed the solicitation terms and gave this to me. That's all that they're required to give you. They're not required to give you debriefing. They're only required to give you that brief explanation of award. And on top of that, because it's day 11, you lost your chance to file a protest at GAO because it's more than 10 days of when you knew or should have known. So you're not only outside of the stay window, you're outside of the timeliness window as well. That is a trap that a lot of people fall into because they're so used to FAR Part 15 or 16 procurements. They think that when they request a debriefing and they get the debriefing, they have 10 days after that to file to be timely, or 5 days after that to file to get a stay. But that is not true because in FAR 8.4 land, that debriefing was not required. And so therefore, none of those rules apply. That is an important caveat there that everyone needs to be aware of. Also, if you ask for debriefing, let's say you're eliminated from the competitive range early in the process. So the award hasn't happened yet, you've been eliminated from the competitive range, you request a debriefing. If the agency says, what debriefing do you want? Do you want a pre-award debriefing or do you want a post-award debriefing? They'll say, look, if you wait for a post-award debriefing, we can give you a bunch of other information that we couldn't give you now because the procurement will be over, we would have made award, and we could tell you exactly why you lost and give you more information. So it might be good if you ask for a post-award debriefing. That's what they're going to tell you. However, if you voluntarily say, no, that sounds good, I don't want a pre-award, I'll wait. Give me a post-award debriefing for all the reasons you noted, agency. Thank you very much. That was very helpful of you, agency. And then you try to file a protest. You might have a timely protest within 10 days of when you get that debriefing, if it's new information that you didn't know. However, you will not be able to get the stay because you voluntarily stayed on your own. Now, the agency might have led you down the primrose path, and you said, well, they lied to me, they didn't tell me that I was waiving my rights. They don't have to. They can delay the debriefing or give you that option. And if you choose to delay it, you're also giving up your right to get an automatic stay by filing at GAO. However, if you file for a debriefing, you request a debriefing, and it is a required debriefing under FAR 15, 16, and then the agency of their own volition, not you, says, we're not giving anyone any sort of pre-award debriefing. We're just going to give everyone post-award debriefings. So after we've made award, it could be months down the road, we will give you that debriefing. If they do it, then you can still file and get the stay because you didn't choose to delay it. The agency chose to delay it. That is an important caveat for everyone to understand. When it comes to debriefings, there's a lot of nuance in when you have to file, and there's a bunch of fact patterns and facts and circumstances that play into this, whether or not, well, did I ask for it? Was that language enough? Am I in a situation where, like, did they delay on their own? Did I delay it? All of the different communications are going to play into that. So it's important to recognize it and to be very careful when you're dealing with things like that. That is a major trap that people get into because you can lose your ability to get a stay, or potentially you lose your ability to protest at the agency or at GAO entirely if things have become untimely because you've waited too long. Again, these are all calendar days, not business days. So if a debriefing, and let's say it's a required debriefing, if a required debriefing is given to you on Thursday before a long weekend, you have 5 days to file that protest. That's Friday, Saturday, Sunday, Monday, which might be the holiday. Tuesday is the first day back in the office. So they gave it to you at 4:45 on Thursday afternoon. That protest is due by 5:30 at GAO on Tuesday. And it doesn't matter that it was a 3-day weekend, okay? It doesn't matter if it was whatever holiday, right? And everybody's out of town. It doesn't matter. You still have to file that. Now, sometimes I think agencies do that on purpose because then the client panics. We get a call, we're working through the issues. It's the Friday usually because it came in late on Thursday. So Friday, we're all teed up. I got my team with me. The client's got their team. We're going through all the possible arguments, working through the issues, and then we got to rush to get things drafted over the weekend to get it ready to be filed on Tuesday. Like, that's how that works. That timeline is very tight. All right. So that's kind of dealing with the stay and the debriefings, how the debriefings tie into when you can get the stay and how all of that process works. Well, let's talk about solicitation defects and ambiguities. These are pre-award issues. And like I said, you generally have to file those protests prior to the date and time for submission of proposals. So to use that example again, if it's 2 p.m. Eastern time, whenever something is due, that the proposal's due, you have to file a protest against any sort of terms or ambiguities in the RFP, or if there's some sort of defect in the solicitation, like let's say there's some restriction on use of joint venture member past performance, for instance. The rules allow you to use past performance of every joint venture member. So if they're restricting it, that might be something you could protest. But because it's a defect in the solicitation that you knew about before you submit your proposal, you cannot wait. You cannot wait till after you lose to raise that issue. You have to file the protest before the date and time set for submission of proposals or bids, sealed bid. That is very, very important. If you don't do that, you waive the right to file that. And that's a GAO, agency, and in most cases at the Court of Federal Claims. There is an exception to that strict timeliness rule. And that is if there's something in the RFP that a reasonable person will determine to be ambiguous. So it could go one way, it could go another way. And if a reasonable person could believe that your interpretation is a correct interpretation, even if there's multiple possible interpretations, that is what they call a latent ambiguity, as opposed to a patent ambiguity. Patent meaning obvious, latent meaning not obvious or sort of hidden, unclear. So when you have a latent ambiguity where you interpreted it one way, then you find out, let's say you lose the procurement and the agency tells you why you lost. You say, well, that doesn't make any sense. I didn't read the solicitation that way. I read it to be a different way. And had I known that, I would have protested prior to the submission of my proposal. You can look at that, and if your interpretation is reasonable, then that could be a latent ambiguity. That allows you to file bid protest arguments relating to the structure or ambiguities in or defects in the solicitation after award. But it's only in that circumstance, only whenever it is a latent ambiguity or a latent defect that you wouldn't be aware of or you weren't aware of at the time. If you have a lot of communications with the agency during the procurement process where you're raising a bunch of issues about something, you're saying this is not clear, agency, you need to correct this, or there's a ton of Q&A all about a particular provision, and the agency's answering things in a very unclear manner, and everyone knows it's unclear. That is not a latent defect or a latent ambiguity anymore. That is a patent ambiguity or a patent defect. It's clear because you know that the ambiguity is clear. The meaning might not be clear, but the fact that there's an ambiguity because of all this back and forth, because of your own correspondence, that could really hurt you if you wait and file later. And that puts companies in a bit of a conundrum because do you file a protest before you've even submitted your proposal, which might upset your customer? They might see you as a squeaky wheel or a problem child. Or do you sit on that and hope it doesn't come up later? Because if it comes up later and you lose because of that issue, you're out of luck. You cannot challenge it anymore. It's a tough business decision that you might have to make, but you need to know you are making it. By doing nothing, you might be making the decision that you cannot protest that issue later because you waited too long, you didn't file it ahead of time. If, though, you have say a modification, and I mentioned this before, but if you have a modification that comes out and it's hours before the protest time, maybe even a day, maybe even 2 days, it's a little unclear how many days you can have this happen. But if something comes out and you don't have enough time to protest, so it's hours, maybe a day, maybe 2 days before the bids are due or the proposals are due, and it really changes the procurement. If it's determined by GAO that you could not have filed, you didn't have enough time to prepare a protest. And if it's less than a day, you're probably pretty comfortable that that's not enough time to file a protest. If you're in that scenario, you have 10 days from that date to file and still be timely. Okay, so there's a little bit of a gamble there, but if you find yourself in a situation where you're completely out of luck, you can do one of two things. You can wait and take that gamble and say, there's no way, there was only 2 hours. This modification drop that was significant. They only gave us 2 hours or 4 hours or 5 hours or whatever before we submit the proposal. That's not enough time. We're going to file a protest, but we have that full 10-day window. That could be true depending on the facts. Or if you want to be careful, you could say, well, we only have 2 hours left. I'm going to file something quick. I'm going to say, this is a protest, this provision's ambiguous, or this is a major change. You have to change your proposal. You have to give us more time. You submit that to the agency via email. You say this is a protest. Once you've done that, you've arguably filed a protest. And then the agency is going to rule on it. And then you would have 10 days from when they rule on it to file something as well. So there are things that you can do if you're stuck in that sort of crunch there that allows you to potentially file something and not be untimely, even if it's a solicitation protest that usually has to be filed before the date and time for submission of proposals. So that's our second session here together on bid protests, going through getting the stay, going through debriefings, and going through solicitation defects. Next time, we're going to talk about some more specific issues with like task orders and joint ventures and corrective action issues, and talk through those sort of protest issues as well. So thank you again.
Thank you, everyone, for joining the PCI Practical Matters podcast. We'll be back again with part 3 in a few weeks.